Good evening. My name is Joe Whitcomb, founder and president of Whitcomb Law PC, and I'd like to take the next 3 minutes to talk about what you can expect to happen once you file a GAO post-award bid protest. So the way this looks is you get a notice of intent to award, and you end up being the disappointed bidder. You didn't get the award. So you then are scrambling about what to do. So your options, as I talked about before, you could file a size or status protest, but in this instance, you decide to land on a post-award, which we refer to often as a technical bid protest. So you're protesting the technical award of the contract. Now there's a litany of different reasons or different bases of these protests, but what you need to know is that you have a very short amount of time in which to operate. If that solicitation was competed under FAR Part 15, which is a negotiated procurement, which the vast majority are, then you want to request a debriefing from the contracting officer, and you want to know that the starter gun started when that notice of award came out. You have 10 days from the date that award was put out, the greater of 10 days from when that award was put out, or 5 days after the debriefing, whichever is longer. So if award comes out, you wait 2 days, you ask for a debriefing, and it takes the contracting officer 5 or 8 days to get you the debriefing, and then the debriefing is completed, you then have 5 additional days to get your protest filed and get your stay affected. And the importance of the stay is it keeps the contracting officer from moving forward with the award of the contract until such time as the contracting officer or the GAO rather has resolved the bid protest. So then once your bid protest is filed, then the government has 30 days to respond to that bid protest, and that begins a new starter gun. Then you have 10 days to respond to the government's response, or give the comments to the protest, to the contracting officer's response, then an administrative record. And those 10 days, again, are hard and fast and required. If you don't file your comments within those 10 days, your protest will be dismissed. Now, more often, or should say, slightly less as often as not, about 40% of the time, the government will issue what's called a corrective action, which is basically saying, hey, you know what, our bad, we made a mistake, we're going to go back and look at the award and redo it. In those instances, your bid protest will likely get dismissed as moot because it's no longer necessary, and the government basically gets a do-over. It doesn't mean you automatically get awarded the contract. It just means you basically get another bite at the apple. Again, my name is Joe Whitcomb. I'm the founder and president of Whitcomb Law PC. If you found this video useful, please like, subscribe, and share. Thank you.